Hello, everyone. It's Anthony Bandiero here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training. Bring another roadside chat. All right, we're going to talk about a question from Illinois. All right, so in Illinois, aggravated fleeing or attempting to elude a peace officer is a Class 4 felony. It also states in the statute that the motor vehicle used in a violation of this section is subject to seizure and forfeiture. That's a big deal. There's obviously other things going on about whether or not you can truly, if a guy in a 2024 Corvette flees from you, can you forfeit that vehicle? Probably not with those facts. It has to be equitable, and taking the guy's $100,000 Corvette may not be equitable for the crime. Regardless, forfeiture procedures are outside the scope of this conversation. All right. Now, the officer goes on to say, many police departments, including mine, do not seize or tow the vehicle that was used in the commission of this crime if it is later located parked. In other words, if we can get them moving, we're good. In some situations, the vehicle is located in the driveway of the registered owner. We attempt to make contact with the registered owner, and many times they refuse to answer the door to speak with us. Can we tow the vehicle off the driveway for evidence? Does it change if it's parked illegally on the street? Okay. So, first of all, I understand that some agencies don't want to tow the vehicle if it's parked. The way I read the statute, I see no prohibition on that. It doesn't seem unlawful. It's still a statutory penalty that is being issued here, against this driver, that it can be seized. It's kind of like it's a punishment for felony eluding. So the fact that the car is still not moving, I don't think is relevant. I think the fact is, do you have probable cause that vehicle was used in this crime? If the answer is yes, the statute says it's subject to seizure and forfeiture. Seizure is, again, it's a penalty in a sense to take their car and maybe even, as a piece of evidence, but also forfeiture implies that it's going to be obviously a civil forfeiture because of the person's conduct. Now, however, if the car is found in a driveway, I do not suggest that you tow it, right? Because you would need exigency in addition to the statutory authority. We kind of get this idea from Collins v. Virginia, where the Supreme Court has held that the motor vehicle exception did not apply to a stolen motorcycle that was parked in a carport. Now, I know that we can have a good, healthy debate about, hey, the driveway is not really the carport, because the carport, depending on how the house is set up, maybe we're not supposed to even be near the carport. The driveway is part of the path up to the front door, right? And if it's part of the path up to the front door, then isn't the car seizable under like plain view? I think that's a great argument. It's not frivolous. We have people that teach for Blue to Gold here that make a very powerful argument that is applicable. However, I'm going to tell you that at the end of the day, I don't think it works, right? I don't think it works because this is not your typical plain view seizure issue, where you just kind of grab and go if you're lawfully present. The problem I have with this is that in most situations, what's actually going to happen is, if it's allowed to happen, the cop is going to go up to the door, knock on the door. He's going to walk by the car, probably get the VIN. He's going to go to his black and white, his patrol car. He's going to call for a tow truck. Billy Bob, the tow truck driver, is going to take about 30 minutes to get there, right, on a good day. Then Billy Bob is going to re-enter the person's curtilage, right? If it's curtilage, this does not apply to apartments, does not apply to shared driveways, but Billy Bob, the tow truck driver, is going to probably enter the guy's curtilage and hook up his car and yank it, right? And I got to say, I don't know where the government gets the authority to later re-enter the guy's curtilage, especially with some random non-sworn person, no agency, and rip his car from his driveway. Where does the government get that authority? And it would be no different than going up to the door, knock on the door, let's say for a knock and talk. You look behind you and you see evidence in plain view, right? And you could grab it and go, but you don't want to. You want to call the detectives. So you get to your black and white, you call detectives, hey, didn't this robbery suspect, let's say it's a robbery suspect and you're doing a knock and talk, right? Hey, didn't the robbery suspect have like a red Adidas jumpsuit? He sure did. Hey man, there's a red Adidas jumpsuit right on the bench in front of his house, right next to his door. Why don't you come by the house and go and grab it? And the cop A half an hour later, goes up to his door, no knock and talk. They just want to grab the red Adidas jumpsuit, take it and go. I believe that the better argument there is that that's an illegal seizure of the evidence off the guy's curtilage because the cop is not lawfully present, right? He already lost the right to be on the curtilage by leaving and so forth. And then the cop re-entering would not be justified in re-entering that curtilage just to seize evidence under these facts, right? Without some form of exigency or consent or, of course, a warrant. So I wouldn't do it, right? And you're like, Anthony, fine. What's the worst that's going to happen? Well, how about a dead body in the trunk? And if you don't think that can happen, why don't you ask the cops in North Dakota about it, right? Where they illegally seized a car, found a female that was raped and killed in the trunk, and the North Dakota Supreme Court, and we're talking about North Dakota here. We're not talking about Illinois, who is trying to, decriminalize crime, right? Right. We're talking about North Dakota that's pretty squared away on their crime control, and they're saying evidence suppressed because the cops violated the Constitution. So at the end of the day, I wouldn't do it. If the car's on the street, though, I would do it. Or at least I'm not telling you to do it because you have to listen to your agency. If they don't want to tow it, they don't want to tow it. But if I was the chief of an agency in Illinois and my cops asked me, hey, if we find that suspect's vehicle on the street, can we tow it? The answer would be yes. And by the way, I would personally do it because that's part of justice, right? We can't chase a lot of people these days. So when we actually get lucky enough to find them later and we have access to their car, it's like on the street, in a parking lot and so forth. I think part of learning your lesson to not run from police is getting your car seized and potentially forfeited by the government. All right? All right. So that's my answer. I hope to help my cops get it right every single time. If you have questions about this or anything else I teach, leave it in the comments below. Until next time, my friends, you stay